All right, welcome back. I do want to talk about, really compare and contrast Napster and YouTube. And by the way, as an aside, right, there was a second case Carol Baskin brought for copyright infringement. If you take a look at the Tech Dirt article about Carol Baskin's case against Joe Exotic, they are very highly critical of the copyright case, and ultimately they do talk about some technical stuff that you don't need to know for this course, but ultimately one could argue that because Joe Exotic was trying to make a criticism, of Carol Baskin, that it should have been fair use, the use of that one photograph. Now, it's a different thing if you're using a bunch of copyrighted photographs, but if all you're doing is just taking one photograph that has very little commercial resale value, even by Joe's own admission, it was, Carol Baskin bought it for $5, right? And he's trying to make what he considers a legitimate criticism of a commercial rival. Most likely it's going to be fair use. But we'll talk more about the dynamics of that lawsuit in Module 5 and what happened to that lawsuit along with the trademark lawsuit. For now, though, I kind of want to end because it's actually very important. Why is it that YouTube is in business? They were bought out by Google, billion-dollar company, billion-dollar subsidiary today, while Napster was shut down. Is it all timing? Or is there actually something different? And I will submit to you there are important differences between Napster and YouTube, legally speaking, though maybe not in terms of business model, since both Napster and YouTube are, free to use. And the main legal difference is something called the DMCA, the Digital Millennium Copyright Act, the DMCA, which was enacted by Congress in 1998. And this actually is probably one of the most important federal intellectual property laws out there, because what Congress did when it enacted the DMCA is it basically struck a compromise. Here's what Congress did. I'm going to simplify it because this area of law can get very technical, and what I've been trying to do in this module, just give you the basic big picture and simplify so you have a good working understanding of IP law. But the reason why I want you to know about the Digital Millennium Copyright Act, or DMCA, is because of what it does. First of all, it says, look, we, the Congress, we're going to extend federal copyright protection to the internet. Anything you post on the internet, or anything that a business posts on the internet that is copyrighted, if you use it or copy it or take it without authorization, that will be copyright infringement, unless you can prove fair use. But with fair use, it's 4 factors, lots of uncertainty there, how a court will apply fair use. For Napster, it didn't work. But that's the first thing. Copyright law and intellectual property law generally does extend to the internet. So that was a very important principle that Congress enacted. And a lot of people, libertarian or free internet types, did not like that. But Congress, in fairness, Congress did strike a very important compromise. And the compromise is this. Though Congress did say that as a matter of principle, copyright law extends to the internet and to websites and platforms, internet platforms. At the same time, Congress said it's up to the copyright owner to protect his or her own marks or copyrights. What does that mean? Well, the DMCA sets up something called a notice and takedown system. What the notice and takedown system does is, if you, bluntly, or just in plain English, it's now up to the owner of the copyright to basically police the internet. And if they see that somebody is using, their copyrighted materials without authorization, then in order to go to court and sue for infringement, first, the owner of the copyright will have to send a notice to the platform that has posted the material and to the person who uploaded the copyright infringing material, and takedown. Give the platform and give the user an opportunity to voluntarily take down, the infringing material. In other words, voluntarily avoid infringement, voluntarily comply with internet copyright law. This is really important, and the reason why I call it a compromise is this. Think of how vast the internet is, right? If it's now up to the entertainment industry to basically police all of these websites, beginning with YouTube, but really YouTube is just the tip of the iceberg. But even YouTube is a huge website with, thousands of hours of material being uploaded every single second. It's just mind-boggling what's on the internet, right? So now it's up to Hollywood. It's up to the copyright owners. It's up to the music industry and the film industry and the TV industry. They're going to have to go out and police the internet. And so now they're going to have to hire a bunch of people to basically monitor all of these websites and seeing what's being posted. And then above and beyond that, they have to give the alleged infringer notice and an opportunity to take down the material voluntarily. In other words, there's a safe harbor. Bottom line is, this is the difference between Napster and YouTube. When Napster got the original takedown notice from Dr. Dre and Metallica, they just ignored it. Or, they gave a big middle finger to Dr. Dre and Metallica. They said, you know what, come after us, we'll defend ourselves in court, we'll try to argue fair use and prolong this as long as possible. No way the courts are going to shut us down. Now that was a terrible gamble that Napster made, and they ended up paying the ultimate price. YouTube, on the other hand, right, couldn't be any more different in terms of their business model, right? YouTube, one would even argue, overly aggressively complies with these takedown notices, even when the notices may appear to be somewhat frivolous or dubious in nature, right? Sometimes even YouTube won't even wait for the notice. Even some of my own videos get flagged because I put too much of a song at the beginning. And so, even though there's been no notice, no takedown request. But the important thing I want you to keep in mind is look at the big picture. It's a compromise. Congress is saying, yes, we're extending intellectual property rights to the internet, including copyright law, but it's going to be up to the copyright owner to go to the time, trouble, and expense of enforcing his or her own copyrights. And furthermore, the owner has to give notice and a reasonable opportunity for takedown, to the alleged infringer before they can sue. Now, if you've gotten notice and haven't taken it down, and it turns out it's not fair use based on those 4 vague factors, right? General factors, based on the 4-factor test of the fair use defense, guess what? Then, you could be shut down by the court, be forced to pay monetary damages, et cetera, et cetera. But then and only then, So that's why I say that law, though imperfect, a lot of people don't like it, it does really, in fairness, represent sort of a compromise between copyright owners who want to extend copyright protection to the stuff they post on the internet, right? But also copyright users like us who would like to copy, borrow, and in some cases you could argue steal or use things that are on the internet freely, right? All right, now I'm going to do a wrap-up video, and I do want to talk about something called the Creative Commons, which is this whole new area of intellectual property, sort of 21st century. So I'll talk about that, what that is, and then just wrap up this module in the next video. We've done a lot. Thank you for bearing with me. I'll see you one more time.